Hey guys, welcome back to my channel, Contracts Unfolded. So, IP disputes are one of the most common disputes in commercial contracts, and these disputes happens because the contracts never really answer three basic questions: who owns what kind of intellectual property, who can reuse the intellectual property, and what happens to the IP once the contracts ends. So in this video, we will be unfolding the main components of a IP clause that should be there in an agreement to make a solid IP clause. So let's start. So the first component of any IP clause should be the background IP. Now background IP is something which one party owns or which already exists to the party, belongs to the party before the contract even begins. Now the problem is many contracts do not differentiate the background IP and project IP. Therefore, the client usually thinks that everything related to intellectual property belong to the clients, and this causes disputes. So one of the practical way to tackle this should be that first of all you should define what background IP is, and then you clearly mention that any background IP will belong to the party who was actually owning it before the start of the contract, and to that you give a license to the client to use the background IP only for the purpose of fulfilling or using the deliverables. And this brings me to the second component, which is the foreground IP or the project IP. Now this is anything which was created by way of a contract between the parties by the service provider for the client. Now again, most of the contracts vaguely defines the IP. In this case, they simply mention that anything created during the contract shall belong to the client, and this creates problem because there was no clarity as to what are the components of all the IP. So to tackle this problem, again the clarity is important, and that clarity can be given by following these steps. The first step is you define what the project IP means, and the second step is you mention or you specify the ownership upfront. Now there are three approaches to tackle this ownership problem. First is everything belongs to the client. The second is the service provider grants a license to use the IP to the client, or there can be some hybrid approach as well. Also, in many contracts, I have seen that the IP ownership is linked to the payment. So the contract says something like this: the IP shall only transfer to the client once the full payment is received to the service provider. And the third component is the difference between the assignment and the license, because most of the contracts use these terms interchangeably. While on the one hand, assignment means the transfer of the ownership, the license only means that you are giving or granting a right to the client to use the intellectual property. And as I said, in most contracts, these terms are used interchangeably. So this creates a lot of confusion. And to resolve the confusion, the idea should be the drafting based on the intent. So if the intent is to transfer the ownership fully to the client, then assignment should be there. And if the intent is to retain the ownership while giving a right or granting a right to use the IP to the client, then the license clause should be there. Also, whenever you are granting a license, make sure to define it properly. Is it exclusive or non-exclusive? Is it perpetual or time-bound? And is it limited to a specific purpose or is it unrestricted? Because this is the clause that actually defines how much control one party holds over the intellectual property. The fourth component is the work made for hire clause. So most contract says the IP developed during this project shall be work made for hire. The problem is that this clause is often copied without understanding. In fact, in many jurisdictions, including in India, this clause does not operate the way people assumes it to operate. So simply relying on work made for hire can backfire you in the future. Therefore, always back up the work made for hire clause with a IP assignment or a IP license clause, which says in case the work doesn't fit into the category of work made for hire, then the service provider is assigning the IP to the client or is granting a license to use the IP to the client. Because if this clause isn't corrected, then there are great chances that you own the IP on paper, but in reality, you doesn't own the IP. The next component is the post termination use of the IP. And this concept is often ignored in the IP clause. And that's why dispute happens between the parties once the contracts end. Since the contract was silent about this, so the parties never get to know, can the client use the IP once the contract is terminated, or can the service provider reuse the IP for other clients that it may get in the future. And the simple solution to this problem is to add a clause about post termination IP rights, licenses that survive termination, or carve outs for generic know-how IP. And there is one another component to the IP, which is the indemnity. Because as a client you own the IP, it doesn't mean you have to fight the battle with a third party who's claiming that the actual IP belongs to them. And therefore we generally draft a indemnity clause related to the IP. But I will discuss about that clause later in another video, where I will be dissecting the indemnity clause in detail. So that is for this video. If you think this video was helpful, then please share it with someone who works in contracts, and please consider subscribing this channel. Thank you so much for watching.